The ICC's charges against former President Duterte focus on only 43 specific killings out of thousands reported. And to provide insights, we are joined by Atty. Gilbert Andres, Deputy Executive Director of the Center for International Law or Center Law. Sir, magandang umaga. Magandang gabi ata sa inyo dyan sa, I think you're still in Europe. Good morning, sir.
Good morning, Ed, and good, really very early morning here in the Netherlands.
Sir, let me start off with that. A lot of questions being raised by a lot of groups here in the Philippines as to why only 43 cases being cited, at least sa warrant of arrest. Some are saying na 43 lang, how could it be crimes against humanity? So, can you walk us through what exactly happened here and why the number 43?
First and foremost, it's within the prosecutorial discretion of the Office of the Prosecutor as to which specific cases it will focus on. Secondly, actually, crimes against humanity, there's no really specific number. In fact, what's at issue in crimes against humanity is that there's a state policy or an organizational policy, and it resulted to a widespread or systematic attack. Now, what do we mean when we say organizational policy? That's a private organization, such as the DDS, of which Mr. Duterte was actually the head. And state policy, that refers to the term under which Mr. Duterte was the president of the Philippines. And according to the legal theory of the arrest warrant, because of the organizational policy of Mr. Duterte through the DDS, and his state policy as president, there was actually a widespread or systematic attack. And the number is actually irrelevant. What's relevant is that it's all across the Philippines, and actually there were patterns to the murders under the EJ, under the war on drugs. So that's the widespread and the systematicity of it.
Mm-hmm. Well, I brought it up kasi there are those who are saying that the math of the anti-Duterte group daw is faulty. Kasi how can 43 be equal to thousands or 30,000 being killed in the drug war? Also, some of them were saying na 43 lang pala. So all this brouhaha daw over 43 people being killed, and some were even comparing it to yung Maguindanao massacre where you had 58 people dying. So what you're saying is basically some people are looking at it the wrong way. We're looking at the sampling rather than looking at the exact number of people who were supposedly killed in the Duterte drug war.
Yes, Ed, kasi the Office of the Prosecutor cannot really present all of those 6,000 deaths that were admitted to have occurred during police operations. The prosecutor cannot also present all of those 50,000 to 30,000 CSO numbers. That includes also the vigilante-style killings. Hence, the prosecutor, in accordance with his prosecutorial discretion, will choose the emblematic cases that will exemplify the widespread or systematic attack against the civilian population. And indeed, the prosecutor here has decided that these are the cases wherein there is evidence that can be supported that will lead to a trial and hopefully to a conviction.
Mm-hmm. Sir, a while ago I was talking to one of the lawyers of the Duterte camp, Atty. Israelita Torreon. He filed last Friday. He filed a supplemental petition, a supplement to their petition for the TRRO, which was earlier denied by the Supreme Court. Now they're arguing na government, it is not yet moot and academic because government can still be ordered by the Supreme Court to make representations with the ICC for the release or return of the former president as well. The government can be stopped from rendering any further cooperation to the ICC as far as Duterte is concerned. Your thoughts about that, sir?
Well, number one, I think the Supreme Court will just have to refer to its previous rulings especially the ruling in Senator Pangilinan versus Cayetano, which was a unanimous decision. In fact, it's also I'm also a petitioner in that case, PCICC versus Executive Secretary. And the portion there is that the Supreme Court will actually not issue a mandamus or any extraordinary writ if it will cause embarrassment to the president as the chief architect of foreign policy. Because, in fact, it's now a fact that Mr. Duterte is under ICC custody. In the same way that when we filed our petition against the withdrawal, with respect to the Rome Statute, the Supreme Court just actually cited the ICC, saying that the Philippines was already withdrawn from the ICC. So I think the Supreme Court will just refer to its previous rulings, wherein the Philippine president is chief architect of foreign policy, and number two, it will not issue any orders or judgment that cannot be enforced, because in this case, it cannot already be enforced because Mr. Rodrigo Duterte is already outside of Philippine territory.
Sir, also still coming from Attorney Torion, he was saying that Section 17 of RA 9851 was not applicable in terms of the surrender of the former president to the ICC because it's either extradition daw or surrender. Extradition, in which case, should go to the rules of extradition under PD 1069, which means it would have to go through the local courts. And surrender daw, basically the same thing. It would also have to go through the local courts. Citing, I think, Article 59 of the Rome Statute. Your thoughts on that, sir?
Okay. First and foremost, actually, if you look at Section 17, it's surrender, may surrender, or extradite. Okay, yes, I will just read the relevant portion, just to be very clear. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state pursuant to the applicable extradition laws and treaties. Now, if we look at the word surrender, my legal position is that it actually refers to a suspect or accused with respect to the appropriate international court. Because remember, the ICC is not a state, so there's no extradition treaty between the Philippines and the ICC, or with any other state for that matter, because it's actually an international court. Extradition process will only apply if the arrest warrant is issued by another sovereign state, because its arrest warrant, it's only operative within its territory and not in another territory of another sovereign state. Secondly, if you look at Article 59 of the Rome Statute, it actually uses the word surrender, because that was actually very intentional. And if we look at TRRO préparatoire of the Rome Statute, the delegates actually use surrender because they see this as not under the extradition regime of state to state, okay? State to state transfer of a person who's being the subject of an arrest warrant. In fact, if you look at Article 102 of the Rome Statute, it says there, surrender means the delivering up of a person by a state to the court pursuant to the statute. And in fact, there's another definition there of extradite. Extradition means the delivering up of a person by one state to another as provided by treaty, convention, or national legislation. Therefore, if we look at Article 59, surrender is very intentional. It only means it does not actually put that person under the extradition regime. Thirdly, Ed, I just want to emphasize, if we are invoking that before the Philippine Supreme Court, which is a domestic court, we will actually invoke domestic law, correct? Mm-hmm. And actually, the operative fact is that we are not anymore a state party to the Rome Statute. Hence, in fact, Article 59 is not anymore applicable
Not
in
applicable.
our domestic sphere. And since it's not anymore applicable, we go back to Section 17 of RA 9851. So that's the applicable legal regime. And since it refers to the Philippine authorities, who is the chief architect of foreign policy who can surrender a person who's being investigated or prosecuted before an international tribunal? The answer is the President of the Republic of the Philippines.
Sir, my last question to you. Over the weekend, si Atty. Harry Roque, of course, representing the Duterte camp, he indicated that they will try to submit a manifestation questioning the jurisdiction of the ICC over the Duterte case, even before the September 23 resumption of hearing by the pre-trial chamber. So several questions there. Number one, is it possible for them to file a manifestation and have it acted on even before the September 23 date set by the pre-trial chamber? And number two, what are the chances here that we're looking at?
Well, it's essentially a challenge to the jurisdiction, and that will be under Article 19 of the Rome Statute. If that's the case, then the prosecution will also be given a period with which to reply to any jurisdictional challenge. And secondly, the court may, upon motion of the prosecution or the defense, may actually set a hearing for that. But in my opinion, I think the chances for a jurisdictional challenge to be successful is not so good. Why? Because actually the pretrial chamber will just look at the three issues of jurisdiction. Jurisdiction rationale temporis. Are the crimes here within the temporal jurisdiction, within the time period within the wherein the Philippines was a state party? And the resounding answer is yes. Because the crimes here are between November 1, 2011 until March 16, 2019. Secondly, the court will also look at whether the crimes occurred within the territory of the Philippines, or that's jurisdiction rationale loci. And yes, they occurred within the Philippines, in Davao and other places of the Philippines. Third is whether or not the crime involved is within the material jurisdiction rationale materiae. Yes, it's within Article 5 of the Rome Statute, which is crimes against humanity. So I think the issue really is the exercise of jurisdiction. But my position is that the appeals chamber also discuss exercise of jurisdiction. So there will be really, I think there's a hard stance to question the jurisdiction of the ICC at this point.
Okay. Maraming salamat to you for joining us this morning, Atty. Gilbert Andres, Deputy Executive Director of Center Law. Thank you, sir, and ingat po.
Thank you.